and it's time now for the Wall Street Beat. Today, we're looking at the Federal Trade Commission's decision to ban non-compete provisions. Now, a number of businesses are suing the FTC to block the ruling. Joining us now is Douglas Brayley, Ropes and Gray partner, following this very closely. Doug, when you look at the good, the bad, and the ugly of the decision itself, some prominent venture capitalists, as we've been talking about, have come out to really support the FTC's decision here, but you have the U.S. Chamber of Commerce pushing back. How do you explain both sides of the argument, given even businesses see this differently?
Sure, and happy to be with you. I think you have to start from the place that, at least in most cases, people are allowed to make what contracts they want to make. And so if a person and their employer agree to a non-compete, why shouldn't that be enforced? But I do hear the point. There are downsides to non-competes, especially when they're overused. It limits employee mobility. It makes it hard for new entrants into markets. There are also good reasons why they should be enforced, at least in certain circumstances. Non-competes are a really valuable tool for businesses to protect their trade secrets, to incentivize them to train their employees, and to protect them from unfair poaching and raiding by their competitors. So it's a really both sides issue. And I think one of the interesting things about this FTC rulemaking is that it comes in over the top at the federal level when there's already a very active debate in all 50 states about whether and under what circumstances non-compete should be allowed.
Now, what's interesting also is the U.S. Chamber of Commerce is leading a suit by business groups to sue to block this non-compete ban. Their statement in and of itself said that the Commission's categorical ban on virtually all non-competes amounts to a vast overhaul of the national economy, reflecting an unlawful and unprecedented exercise of bureaucratic power. How do you think their suit might proceed at this point? And how long will it take to get this sorted out?
It may take a while. They've filed in the Eastern District of Texas, and they are going to, I think, seek an injunction while the lawsuit is pending. In other words, an order from the court saying, hey, FTC, you can't put this rule into place while the courts are considering it. And I have to assume that whatever happens in the district court, there will be an appeal to the Fifth Circuit, and then I think likely an appeal to the U.S. Supreme Court. This is a really important issue. It's of nationwide importance. And so it seems likely to me, not guaranteed, but likely that the U.S. Supreme Court would take it up. So we're talking months or years before those lawsuits would be resolved.
Well, it's interesting. Unions are very much in favor of this as well. But of course, this is a decision being made into the U.S. presidential election as well, where we don't know how things are going to go if there were to be a change in administration. Is some of this symbolic?
It may be. I mean, you've seen executive orders from the Biden administration talking about non-competes as one of the focuses, and it shows a commitment, or at least is intended to show a commitment to workers' rights. So there's a lot of politics here. And I think that's one of the points that the Chamber of Commerce and other challengers are making is, look, this is a 100-year-old law that the FTC is interpreting, but it's the first time that they're doing so in the context of non-competes.
What about the path forward for employers? With all of this uncertainty, do you think that they should be or are already making any changes to how they view their contracts and non-competes?
I think the question of the non-compete specifically, they should wait and see, because it'll be really important what's happening in the courts. But in the meantime, what they can do is look at what agreements they have in place, make sure they have a good inventory of the non-competes they have in place, and think about whether there are other restrictive covenants that they could put in place in the meantime to make sure they're protected in case the non-competes get invalidated. So, for example, do you have good customer non-solicits or employee non-solicits? Do you have good non-disclosure agreements? Are you protecting your trade secrets the way you should be? There are a lot of things you can do short of non-competes that give you at least some measure of protection. And now would be a good time to make sure you have those in place.
For the states that already have this rule, how does it play out for them? And what kind of changes have employers really seen in those areas?
So there's no state that has a rule quite like the FTC rule. The FTC rule is broad and almost without exception. Even California, which has not allowed non-competes for a very long time, generally has carve-outs for the sale of a business and for partners and for members in an LLC. And some of those exceptions do not clearly appear in this FTC rule, and it's at best unclear what will happen in those scenarios. I think other states that have limited non-competes recently have other carve-outs. So Massachusetts, for example, limits the use of non-competes but doesn't ban them. So this FTC rule is very broad and actually pretty unprecedented.
Well, what do you think that it means for the entire workforce, given that there's kind of a threshold here for the FTC's rules in particular?
I think it's something everyone should be paying attention to. Look, I think this is most important, or not most important, but it will be especially important to the financial services industry and to the private equity industry, where they're dealing with complicated business arrangements, highly paid executives who really have a lot of access to trade secrets and goodwill. And there they really want to be buttoned up. For workers who are paid less, who don't have that same access to trade secrets, there are better arguments that they should not have been subject to non-competes in the first place.
What does it mean for the FTC to have gone kind of above and beyond the states to begin with? Do you think that ultimately they can get something through that's just more watered down?
I think it's a really open question how the FTC rule will relate to the state level rules, because at bottom, non-competes are contracts, and contract law is a state level question. The FTC has come in over the top and said, we think it's a violation of the FTC Act for you to have a non-compete. But that's not the same thing as saying we're overruling state law and you can't enforce a contract as a matter of state law. So I think there's actually a pretty tricky constitutional question about the supremacy clause, about how those state laws and the federal laws will interrelate.
It's interesting. You kind of mentioned the private equity industry being one of the places that might be more heavily impacted. Are there other places that you see finding impacts to this most clearly? And, should they be considering at least thinking through future policies, given it would change a lot for them?
Yeah, it's really any industry where they have highly compensated workers who have access to sensitive information or trade secrets or goodwill, and who have formal employment agreements in place, right? So we're not talking about line manufacturing workers. We're talking about financial services industry. We're talking about biotech, technology generally, places with highly compensated, formalized employment agreements. That's who should be paying a lot of attention to this.